Welcome everyone to Taking the Bar, the show where local lawyers and lawmakers answer some questions about the law and politics, a little bit about themselves, and have a drink while doing it. My name is Matthew Mobilio. I'm going to be your host today. I'm an attorney with the Mobilio Wood law firm. Today's guest is Ralph Lamar. Ralph is an employment attorney in Allentown, Pennsylvania. He's been practicing employment law for over 30 years. He has numerous six-figure plus jury verdicts and settlements to his name. He's a member of numerous employment lawyer organizations, and has a unique distinction of having been named a super lawyer in both Colorado and Pennsylvania. If you're looking for an employment attorney, you can find Ralph at lvemploymentattorney.com. Ralph, welcome to the show.
Thank you.
Thanks for coming. And we are here today at the Greenhouse in the west end of Allentown. This is Salvatrice. Salvatrice is the owner of the Greenhouse. We are taking over the bar at the Greenhouse here today. Salvatrice is going to be our bartender, and she's been cooking up something for us behind the scenes here. And what are we having today, Salvatrice?
So this is our old fashioned that is smoked, and we make it with a local bourbon from Explorer. They're from Quakertown, and this is a Funk Citrus from Emmaus.
Thank you.
Wow, look
Cheers.
at that. Thank you so much. Wow, it smells amazing. Oh, that's delicious. Thank you so much. Ralph, are you ready for some questions?
Sure.
Okay.
Sure enough.
All right, I'm going to try to take it easy on you. Okay?
Oh, thanks.
Actually, before we get to that, I just want to read a little bit about the Greenhouse. The Greenhouse is an urban winery and restaurant that sources locally and serves organic and sustainable foods. They feature only ranchers who have a humane and compassionate ethos. Wine enthusiasts rave about the small batch wine made on the premises, and they have the hottest pizza maker in all of the Lehigh Valley, in all of the West End. Amazing pizzas. I cannot wait. They're going to be cooking some up for us when we get done here today, so I can't wait to try some. Thank you so much, Sal. All right, thank you. All right, Ralph. When people hear the term employment attorney, okay, they think about unemployment compensation, workers' compensation, that sort of thing. Is that what an employment attorney is?
No.
Okay, so tell us what it is then.
Employment attorneys typically handle discrimination cases. Back in 1991, when the Civil Rights Act was passed, fee shifting provisions were included. So basically, when people have been discriminated against on the basis of a protected characteristic, age, race, gender, religion, disability, that's what an employment lawyer will typically handle.
Very serious, high-level stuff, very important, obviously, in our society. What made you decide to get into that sort of thing?
I started as a workers' comp claimant attorney. Okay. And in Georgia, when I was practicing as a new lawyer, it was legal to fire people when they filed a claim for workers' compensation. And I thought, this can't be right. And right about that time was when the ADA was passed. And the ADA has provisions for both regarded as claims.
And when you say ADA, you mean the Americans with Disabilities Act,
I do.
correct?
I do. Thank you.
Sure.
And it made it very clear that if you had suffered a workplace injury, your employer couldn't fire you anymore because it was typically going to be a serious injury. We're not talking about a cut on the finger that needs 2 stitches. Mm-hmm. But if you suffer a serious back injury, then you can't be fired for it.
So that doing that in the workers' comp context made you realize, hey, there's important fights to be fought out there.
Indeed.
Now, I do employment law as well. Obviously, that's how we became friends, and over drinks, of course. So I know that you have some crazy stories about crazy cases, crazy judges, crazy clients, crazy opposing counsels, you name it. So we got to hear at least one or two.
I do. Okay. Well, one of the cases, and I practiced in Pennsylvania for 12 years, from 1998 until 2010, before I went to Colorado. I represented a fellow who was a bus driver for BARDA, the Berks Area Rapid Transit Association.
Berks, like Berks County,
yes,
Pennsylvania.
Berks County, Pennsylvania. And he had driven for them for 30 years. And he got hurt, so he went out of work, and then on a return to work or return to duty exam, they instituted a colorblind test, and he failed. And the doctor said to him, "Well, Bob, you're colorblind." He said, "I know." So the doctor disqualified him.
And how long had he been doing this before he got?
30 years.
Okay.
So he'd been driving them with no accidents for 30 years. And he called me up and he said, "I got fired because I'm colorblind." I said, "Well, does it allow you to does your color blindness allow you to drive a bus? And he said, not interstate, but I was doing it regionally, and there are no rules regionally. And BARDA had fired him because they were worried he was going to run through a red light. And he says,
even though he had done it for 3 decades.
no. And he says, Ralph, the red is the one at the top. And that just tees up how stupid some of these employers can be, that they do things with just a knee-jerk reaction without thinking about it. It didn't end up going to trial, but that was one of my unusual ones. Another one was, if you're a fan of Seinfeld, you know about the
Yeah, well, I was born in 1980, so I have to be. It's contractually obligated.
the poppy seed bagel case.
Oh, yes, of course.
I had a poppy seed bagel case in Florida, in which my client had gone for a pre-employment physical. They took some blood. It came back positive for opiates. And she said, I didn't do any drugs. So she went down the street and had a private test done. And he said, well, did you eat anything for breakfast the day of your test? And she said, yeah, I had a poppy seed bagel. And he said, the testing levels are so low that if they knew what they were doing, they would have asked you. And they would have said, yeah, there's no evidence whatsoever of you being a heroin addict.
So you
hers
won that
went to
case?
trial, yes.
Okay. So tell us what happened in trial. I'm sorry, I interrupted you.
That's okay. The really neat thing about that case was that I was not doing the discovery. And discovery is the pre-trial work where you get all the statements from witnesses. And another lawyer had done that. And I was practicing in Savannah. She practiced in Tampa. It was somebody I found through the internet at the time. And she didn't take enough depositions. So I went into this trial not really knowing what we were going to hear. And at the trial, I was the one who was examining the HR representative. And I just threw out a question. And in law school, they tell you never ask a question that you don't know the answer to. But I figured it can't hurt. So I said to her, were you familiar? Had you ever heard about this before? She said, oh yeah, about 6 months ago, a woman came in. We had the same issue. She even had a newspaper article that she gave me. I said, oh, well, after reading the article, did you rehire her? No. I said, well, what did you do with the article? She said, oh, I threw it away. The looks on all the jurors' faces, they couldn't believe it.
That's
So
the best
that was
feeling
the
on catching.
last nail in the coffin for them.
Nice. I know that's the exception to the rule is those crazy funny stories, but I mean, obviously it's important work that you're doing because it's keeping employers honest because they, a lot of these employers don't take the time to learn what the laws are and they just think they know what the right thing to do is and they fire someone for a silly reason.
I feel like the little Dutch boy with the finger in the dike. The reality is there aren't enough people like you and I doing this, which is why there's always work for us.
Well, it's a good segue because one of the next questions I really want to talk about was, when we talk about harassment, discrimination, there's really one set of laws, right? There's Title VII and there's Section 1981. I wouldn't say it's one set, but that's kind of those are the federal laws that really govern federal discrimination issues. You practice law out in Colorado and in Pennsylvania. Even though there's one kind of set of guiding principles, states interpret them different ways. Do you have a sense of how Colorado might see a law differently than Pennsylvania? Do you see there being a difference, or is it just kind of, there's really just minor nuances, but they're very similar?
They aren't, and there are 12 circuits in the United States, and they're divided up by geography, and it's by population. And the Second Circuit, which is New York, Vermont, and Connecticut, is probably one of the most liberal circuits. The Third Circuit, which is where we are, Pennsylvania, Delaware, and New Jersey.
And the Virgin Islands.
And the Virgin Islands.
I forgot about the Virgin Islands.
I did.
Can't forget them.
Well, is fairly liberal as well. And so is the Ninth Circuit, which is the West Coast.
California.
But everything else, the South, the middle part of the country, the judges are much more skeptical of the law. They do a much poorer job of interpreting the law in favor of the employee. And so whenever there's an unsettled issue, if you're looking for a circuit that's taking a pro-employee position, it's typically the Northeast or the West Coast.
Do you find that when you do see a situation where, say for instance, I know I do this, and maybe it's a fool's errand to even do this, but when I get a new judge on a case, I look and see who they were appointed by. I can look up their Senate testimony. I can really kind of delve into what that person's background is. But a lot of times, and you'll see with the Supreme Court of the United States, where you nominate someone because you think they're going to be one way, and then they turn out to be a Justice Breyer, for instance, who Justice Breyer was, I think, he was
One of the most famous ones.
right.
He was a George H.W. Bush appointee, and he
out to
turned
be
out
most
one of the
liberal-
most
right,
liberal
right.
judges on the Supreme Court.
And you know, it's I've seen it not to that degree, but I think it's interesting that you're dealing with judges on a federal level that were appointed by the president, but don't necessarily share their views. But at some point in time, the president thought they did, and so they gave him this lifetime appointment. And then here you and I are as practitioners trying to figure out, you know, what's going through their head when you have a sexual harassment case or a race discrimination case going before them. It makes our practice, you know, interesting.
Those are incredible points, and I agree. I try and do the same thing too. You know who else? Before Justice Breyer became the biggest turncoat, William Brennan. He was appointed by Ike. Ike appointed him from the New Jersey Supreme Court, and he look, he ended up bald. Tore out all his
There's
hair.
nothing wrong with that.
No, there's nothing wrong with it, but I think he decided that William Brennan was not the best choice.
Well, you know, obviously you've had an awesome experience, very interesting and very, you know, nuanced and eclectic experience, I'll say. But you've litigated many discrimination cases, harassment cases. Do you think the system works? If you, you know, do you think that someone who's legitimately discriminated against has a good shot or a great shot at getting justice in our current system as it
I think it's broken in 75% of the country.
Can you expound on that at all?
Having practiced in Colorado for the past 10 years, it's my belief, and it hasn't just happened in Colorado, because I'm a member of, as you said, NELA, the National Employment Lawyers Association. Circuit after circuit after circuit has been ignoring Supreme Court law, sometimes flouting it openly, sometimes a little less than open. Their approach at summary judgment, they're supposed to treat the facts in a light most favorable to the non-movement, to the employee. And they, time and time and time again, these judges don't do that. And there are a number of reasons why, but unfortunately the jury system is dying. It's dying on the vine. And when you combine that with the move toward mandatory arbitration, I'm an idealist at heart, so that's why I'm still doing it. But I came back to Pennsylvania because I could no longer represent people in Colorado and look them in the eye and say, you can go to trial and you can win.
Ralph, thank you so much for joining us.
My pleasure.
Keep up the good fight.
Will do.
That's all the time we have for Ralph. Thank you to Ralph Lamar, discrimination attorney extraordinaire. Thank you to Salvatrice and the Greenhouse for hosting us here today. Ralph, anything before we go that you can plug, whether it's your website, a blog, a charity, your pit mix that you have at home, anything you could plug while you're here?
Give blood products. Donate blood. Plasma, platelets.
Excellent. Excellent. Thank you again.
My pleasure.
Everyone stay safe, don't drink and drive, and remember to always tip your bartender. Thank you.